18-30979, Hughes versus Vannoy. Ms. Rutzen, is that right? Okay. I just don't want to butcher people's names, so names are important. So, all right.
Right. Good morning. I'm Allison Rutzen on behalf of Appellant Warden Vannoy. This habeas case examines whether the Louisiana court's rejection of a Strickland claim involving counsel's decision not to interview a witness is so far out in left field that every fair-minded jurist to consider it would disagree with the result. That is not the same as asking if counsel's decision was reasonable. This is a much more limited inquiry, and it requires double deference. Deference to counsel's reasoned performance, and then again to the state court's assessment of that performance. Here, this court must ask what theories and arguments existing in the entire state court record could have supported that court's decision. The Middle District didn't do this. Their grant of habeas was wrong and needs to be reversed for three main reasons. First, they failed to recognize their limitations under AEDPA, which is not a substitute for ordinary error correction, but aims to correct extreme malfunctions in the state court system. Two, in ignoring these AEDPA parameters, the Middle District essentially conducted a de novo Strickland analysis, and they relied upon Fifth Circuit, non-controlling Fifth Circuit case law that was issued pre-Richter and pre-Knowles. And third, in reaching their conclusion, that court cited certain portions of the state court record, but they ignored others. For example, to support their prejudice finding, the court found that had counsel interviewed Ms. Sandra Allen before trial, he would have discovered her roommate and discovered the existence of her news interview, and that these tools would have allowed counsel to impeach Ms. Allen at trial. While this may be true, this completely overlooks the fact that Sandra had nothing to offer with respect to the main issue before the jury, which was, did Mr. Hughes act accidentally or with the specific intent to kill or inflict great bodily harm upon his victim, Drew? The strongest evidence on this point was Mr. Hughes' testimony, which the Middle District didn't even consider. Had the Middle District applied the clearly established Supreme Court precedent, they would have noticed the stark evolution in Strickland claims under AEDPA, wherein, by design, relief is few and far between. Some of this case law, the case law maintains that Strickland is meant to be a case-specific inquiry. We are looking at counsel's decisions based on the context of the totality of the circumstances and based on his perspective at the time, not based on hindsight. And there's simply no case from the United States Supreme Court, the only law that is applicable on the state courts in this situation, there is no case that has ever held that counsels must interview all witnesses before trial.
But counsel, wait a minute now. This is an eyewitness.
Yes, Your Honor.
Relatively limited universe of witnesses. There are, what, 4 or 5 folks, correct? So this is a witness that the government disclosed, what, a week before the trial, and that the government disclosed was going to directly implicate the defendant here, right?
Yes, Your Honor. Everyone knew of Ms. Allen from the time of the occurrence. It was not until a week before trial that the state learned that she had actually witnessed the shooting and the events leading up to the shooting.
So explain to me how it is that the defense counsel wouldn't have interviewed a witness who actually turns up to have been an eyewitness. And in fact, to me, it almost shines a more glaring light on this witness because it's a week before trial that it is first revealed that this witness saw what happened and is going to testify about that. How is it reasonable for counsel not to have interviewed the witness?
Well, Your Honor, Counsel Scott Collier tells us at the PCR hearing that he discovered this on a Thursday. The case was headed to trial that following week, and so he and his client, Mr. Hughes, who was out on bond in this case, met, and they talked about what to do. They talked about either, maybe going and investigating her and getting an extension, which would have been their second extension here, or they thought about what evidence they had, which was Sandra's two prior statements where she said she didn't see the events leading up to the shooting. And they decided that they were going to get her to lock in to those statements and that she would not be very persuasive when she comes with a second story.
But her testimony was going to be that the victim had his arms raised and when he was shooting. The testimony is obviously very, very potent. I mean, it's not just a peripheral witness he should have interviewed that might have led to someone to go down some path. That testimony itself was critical in this case. And lawyers didn't, whether he considered it or didn't consider it, it's very difficult to justify why he would not talk to her or attempt to find out because her story was apparently a changing story from time to time.
Yes, Your Honor.
So do you agree that was an error or?
You know, at this point, we're second-guessing counsel's decision. And
a strategic decision to do what? To not to interview the witnesses, going to have his client shooting a man with his arms raised?
not to interview this witness, but to impeach her in other ways. They decided to get her to lock into her testimony.
Impeach her testimony, then.
Impeach her testimony via the law enforcement officials that were out there that evening and via petitioner's other daughter, who were poking holes in all of this testimony here. And whether we agree with that decision or not, it was a strategy. Whether it was successful or not, it was a strategic decision.
Just dropping the label strategy on it does not give it any greater legitimacy in the terms of answering the question of error, basic fundamental of failure of counsel. You can call it strategy, but it is such a good. You label it strategy, but I see no strategy to this. I mean, I make a decision. I'm not going to interview a witness that's going to the nail in the coffin of my client, and I don't do that. I have a grand strategy. I'll impeach him. You know, I'm just like on TV. The guy's going to collapse on the stand. I have a difficulty with the argument. There are a lot of other problems down the road for the petitioner, but the categorization of this as a matter of strategy and hence not cognizable, I find that very, very difficult to accept.
And, Your Honor, we're free to disagree on that point, and even if you agree that counsel was deficient for failing to interview Ms. Allen, Mr. Hughes would still have to prove prejudice. And under AEDPA, he would have to show that every reasonable jurist to consider this issue would conclude that it is reasonably likely that he would have fared better at trial.
If any one juror would have acquitted, do you think the jury had to be unanimous on that? If all you have to do, the defendant has to do, is convince one juror. At least that used to be the law.
Yes, Your Honor, but let's look at this. What would Sandra Allen have really offered to the jury? She didn't hear what was being said. She was some 300 to 400 feet away, and she saw these events as they unfolded. She saw the push and the tug struggle, and she saw the arms up. Mr. Hughes testified. He corroborated her story, and he filled in the gaps that she could not. He told you why he went over there that night. He told you what he said to Drew, to his victim. And, so...
Counsel, wait a minute. Now, it's the difference between this witness testifying that she saw the defendant shoot somebody walking away or stepping back with his hands up versus being inside her apartment when the shot was actually fired and seeing everything after the fact. I mean, that's a pretty big difference.
Yes, Your Honor. Her testimony at PCR, though, she is still not recanted. She still admits that she saw something. If you look at Sandra's PCR testimony, and that's at record pages 368 to 376, she still says she saw something.
Well, seeing something is unremarkable, but either witnessing the shot versus seeing the aftermath, is kind of radically different. Both of those are something, but they're radically different somethings for the purposes of the jury. And back to Judge Higginbotham's point about the jury, this was an 11-1 verdict, correct?
Yes, Your Honor.
So basically, one juror already said, I'd vote to acquit, presumably. So you needed, what, 2 more? I mean, doesn't the fact that it was a non-unanimous jury verdict as it is suggest prejudice?
Your Honor, the issue of it being a non-unanimous jury verdict would be a separate issue that was not briefed here. And
My only point is that basically if 2 other jurors became convinced because of an adequate cross-examination, that's it. It's an acquittal or a hung jury, right? Not a conviction.
Yes, Your Honor. The issue that we're having today, though, is under AEDPA, and we have to take a step back and look at this entire state court record to see if it could have been, if there are reasons and theories in this record that could have supported the trial court's ruling.
But the path you were on was, you were asked the question, even assuming deficiency, moving past the earlier point, and you said, but the defendant would still have to show prejudice. That's where you went.
Yes, Your Honor.
To which then you were given a question, was 11-1 here? And so the question was not whether the conviction by 11-1, resolved by Ramos, Edwards versus Vannoy, is in this case. That wasn't what was being asked. You said that's a different issue. That wasn't what was asked. The question was whether the 11-1 was potentially an indicator of prejudice, not a separate issue not argued in the case, but whether it was an indicator of prejudice since you had shifted to the prejudice prong. That was the probative nature of the question.
Yes, Your Honor, and I wasn't categorizing Judge Wilson's question as an unfair question by any means.
I didn't say you were. I'm not trying to help him out. He can take care of himself over there. I'm just interested in the point. I just like counsel's way of nimbly moving away from what's being asked. That's all. I just am amused, not amused, but able counsel can nimbly kind of move away. And it just seemed you were headed that, the 11-1 piece isn't argued in the case, and we get that, but just not to be confused. The point was just, in this fact scenario, wouldn't that, on the prejudice prong, since that's where you were headed, be some indication, not necessarily dispositive, but...
Yes, Your Honor, and it may be an indication of some sort of prejudice, but is it proof of an extreme malfunction in the state court system? I think not. If you look at this trial court's rejection of the claim, it was Judge Bonnie Jackson, who was recently retired. She was a very well-respected member of the 19th Judicial District Court. She'd been a former public defender for nearly 2 decades before she took the bench, and she was the presiding judge over trial. She was able to evaluate all of the witness credibilities. She was able to see when those parties were talking about how their hands were up. We don't know from our record, were they surrendering, were they defensive, were they pushing away? She saw those determinations because there are several record instances where the witnesses are saying, like this. From our dry record, we miss those details. That's the disadvantage that us appellate practitioners have.
What do you do with Bryant case?
Bryant was a Fifth Circuit case issued in 1994. It was pre-EDPA. And under EDPA, Fifth Circuit case law is not binding on the courts. It might be persuasive, it might be instructive, but it's not binding on the state court. Strickland remains a case-specific analysis, and Strickland didn't say you have to interview every witness. No Supreme Court case law has ever said that.
Strickland just insists that the defendant be represented by counsel, competent counsel, and that it will allow relief for decisions that rise to the level of are not defensible as strategy, whatever, a failure of counsel, and that you got relief only in those circumstances, very narrow circumstances to be sure. But
Yes, Your Honor.
if you can't defend this as a matter of strategy, you have to defend it on the basis that it wasn't prejudicial.
Well, Your Honor, Ed narrows Strickland even more.
And that's the question under Strickland, and that would be that you only have to convince one member of the jury. Actually, this verdict would not stand if the Supreme Court's recent decision on unanimity were retrospective, but that's neither here nor there. But as my colleague has pointed out, it did succeed here with one juror.
Presumably,
So
yes.
you have to assume that, well, no, this wouldn't have had an influence. It's not prejudicial. But some of it's just the question of the level of certitude that's required in order to vindicate these federalism principles. That's the issue, right?
Yes, Your Honor.
And in Bryant, we said that virtually for identical fact. We said that, and that may not be the requisite metric measuring for this, but it is highly relevant to the characterization of this type of failure.
Yes, Your Honor, you did say that with Bryant. I noticed my red light is on. If I may finish just this one point. If you look at the more recent Fifth Circuit case law under AEDPA, the habeas grants have been very few. This court is starting to recognize that counsel is free to choose how to best utilize his finite time and money. And if you look at all of counsel's testimony here at the PCR hearing, record pages 377 to 419, this man put a lot of time and effort into defending this case.
Did counsel, did he Google this witness or do any kind of search background in preparing?
Did he Google Ms. Allen?
Yeah, just to find out like what she says on Facebook. I mean, you talked about impeachment being the strategy, so did he do any of that kind of searching to figure out other grounds?
Your Honor, this happened in 2004, so it was a little bit before Facebook was the norm, and this woman was a 60-year-old lady, so I don't think she was on Facebook or even on the internet very much. I don't know.
But an internet search would have found that TV interview.
It may have, and he may have been deficient on that point, but if you look at the First Circuit's denial of the motion for new trial, which he had gone to the effort of transcribing her 2 lines in that interview. He'd gone through the trouble, and that's in our record excerpt, page 49. And he put that in his motion. The trial court denied it, and the First Circuit Court of Appeal in Louisiana on direct review also denied it and found that it was not the type of evidence that would have proven or that would have led to a different result.
All right, Ms. Rutzen,
Thank you.
you've reserved your rebuttal time to come back up. All right, Ms. Hogan.
Good morning, Jane Hogan on behalf of George Hughes, and may it please the court. In order to reinstate George Hughes's conviction and reverse the district court, this court would essentially have to reverse 20 years of precedent. You mentioned Bryant. There's also the case of Anderson, Sofar versus Dretke, cases in which this court has repeatedly held that the failure to interview a critical eyewitness, a material witness who could have made a difference, is deficient performance, and in cases in which the record on a whole, the evidence is shaky one way or another as to guilt or innocence, that deficiency results in prejudice. Just to respond to a few things, I would like to...
Well, cut to the chase.
The chase...
What do you do?
What do I do with EDPA?
No, what do you do with Mays? You know, Supreme Court came down with Mays a couple of months ago. You know, you've got, I mean, it's a death case, and the trial judge had denied relief, you know, similar situation about interviewing witness, da-da-da-da-da-da. The Sixth Circuit, 2-1, you know, reversed and, you know, found that there should have been an investigation. Judge Kettler's dissented. Supreme Court issues a per curiam opinion, 8-1, Justice Sotomayor dissents by just saying, I dissent. But 8-1, you know, they take a bite out of the Sixth Circuit. It's an old case, and, you know, they kind of go on and on about the evidence in the case and the age and this and that, but it has within it the issue of the extent of, you know, investigation and the witness and so forth. Now, obviously, the facts are different here. Every case is different, but I'm just saying the ink's hardly dry. It's 8-1.
Yes, Your Honor, and I would say, first, as you pointed out, the facts are completely different. Maines had overwhelming evidence of guilt. I believe that Maines is actually helpful to our case. There was overwhelming evidence of guilt, which the Sixth Circuit neglected to recognize in reversing or granting habeas on a technical legal issue. What the Supreme Court says in Maines is that habeas is warranted when there is an unreasonable view, when the state post-conviction court has taken an unreasonable view of facts and law, which is difficult to meet. This is not about ordinary error, but about an extreme malfunction in the state criminal justice system. And, Your Honors, that is what we have in this case. If you review the entire record on state post-conviction was filed in 2009. In 2013, there were...
Before you leave Mays, just what do you do with the Supreme Court's commentary, though, about the unreasonableness prong of it vis-a-vis the state court's determination, because that's where the case resolves itself. And so I'm just asking, and I'm glad you addressed it straight out, but I mean, that's the language we're floating around, you know, the unreasonable application of the state. So what do you do with the language or distinguish it or whatever in the context of there and in others? You have a state court determination, albeit, as you said, overwhelming evidence, but you got that. And then you got here, and so we have the same. So where are we, you know, kind of in the zone there? We're all reading the same cases, right?
Yes, Your Honor. And reviewing the state court record, you have a 22-page counseled commissioner report. This is the commissioner who presided over the evidentiary hearings, read countless briefs that were filed back and forth, and in 2014 he issued a 22-page opinion recommending that George Hughes be granted a new trial based on several deficiencies, one of which was the failure to interview Sandra Allen. The district court rejected that in a one-word, having considered petitioner's application for post-conviction relief, the record and the law applicable, petitioner's claims are hereby dismissed without the necessity of a hearing. The
Commissioner who made the, I'm just sort of playing devil's advocate, the commissioner who made the determination, that's the unelected person. Is that person a lawyer?
I assume he's a lawyer. I don't know that he's
I mean, it was kind of a strange system to me.
It is, Your Honor, and I don't practice
Kind of an
Michigan Latin,
oddball
Your
deal
Honor.
to me, but
Yeah.
oops, I'm on the record, sorry.
So, I mean, evaluating the state court record as a whole, it was unreasonable for the Supreme Court to then find that there was no Strickland inquiry satisfied because there was a 22-page opinion saying counsel rendered deficient performance, and there was no opinion to the contrary either by the trial court, the First Circuit, or the Louisiana Supreme Court that expressed why the commissioner's findings were wrong.
It's such a mixed deal. You have the commissioner that found, as you just said, then you get the trial judge who summarily rejects
Yes.
what the commissioner says. Then you have the proceedings up through the state chain, First Circuit, Supreme Court of Louisiana, on and on and on. So, I mean, we've got, you know,
It's been 11 years on collateral review.
sort of, but I mean, it's this mixture in terms of everybody's looking at the same thing.
What I would say to that is that this case is different than Maine's, because in Maine's, the Tennessee Supreme Court or the Tennessee court, state post-conviction courts gave a counseled opinion rejecting the ineffective assistance of counsel claim because they put great weight on the overwhelming evidence of the guilt, and that's not happened in this case. The Supreme Court denied Mr. Hughes' post-conviction in a one sentence opinion. The trial court did the same. The only extensive.
What is the Supreme Court, again, I'm just pushing back, but what has SCOTUS told us about, you know, getting these one-liners and da-da-da-da, I can't remember which
But you
case
look
it is. The
through.
court says you look through
Yes.
to the looking glass
That's
to
right.
find the last reasoned opinion when somebody opined, and you do all of this algorithmic, this cognitively algorithmic searching for who said what about what. So Judge Jackson says nothing. She just gives the back hand to the commissioner's long report. But I'm just saying, you know, just
If
asking
you were
questions.
to look through if you were to look through the state court proceeding, the only reasoned, extensive discussion of the merits of these claims came from a 22-page opinion rendered by the commissioner in 2014.
Okay, keep going. I interrupted.
No, you're fine, Your Honor. I welcome the questions.
To meet that head on.
Well, counsel, we've been focusing on the failure of counsel to interview this particular witness as being the error. We also can, it seems to me, to frame this as a failure of the counsel to investigate the case in general. In other words, what happened here is he didn't talk to the witness, and the witness then we know opened a door to another chain of testimony of the roommate, and so it said that she didn't see this thing, that's so when we look at the question of prejudice, the failure of counsel, it is really best framed as a failure of counsel to investigate. It's not just that he didn't interview this witness. When bypassing a witness who is there, he bypassed the opportunity to examine, to go further with that witness and to the other people who were standing behind that witness itself. And now the jury would have been told that my roommate didn't see that. And that itself seems very difficult to walk away from. So to me, I see the case not so much as just stopping with a single witness there that he didn't interview and you could impeach him, et cetera, et cetera. That in of itself has a lot of bite, but it's the failure of counsel in my eyes here is simply to investigate the case. The notion, well, I'm just not going to talk to him. I can do this. I can cross-examine and so forth, and I can understand that. But the weakness in that is that, and it shows the inexperience of the counsel. That ain't the way you prepare to defend the criminal cases, and that is just, as my granddaddy would say, that's just Ned the first reader.
No, exactly. To your point and to Judge Wilson's point earlier, I mean, this is a critical witness, and it's not just.
I thought you'd agree with it. I was just
No, it's not just the failure to go and conceivably hope that there's somebody that might have seen something and canvass the neighborhood, which I submit should have been done in and of itself, but that trial counsel was informed 7 days before trial that Sandra Allen was going to testify differently, that she was going to testify that she actually witnessed the shooting. And during the post-conviction evidentiary hearing, Sandra Allen did not state, she only ever stated that she saw the surrendering during trial, which is different than what she told the police initially. It's different than what she told the news people who interviewed her on video. And it's also different than what she testified to at the evidentiary hearing. She said at the hearing that she went out and she saw a scuffling over the gun. But when asked, did you believe that you were in a position to know whether one person was surrendering at the time, she said no. So this is trial testimony that she gave that was incredibly impeaching, incredibly damaging to Mr. Hughes. We've got 3 witnesses, alleged witnesses, to this case. We've got Mr. Hughes, his daughter, and Sandra Allen is the only disinterested witness. So it was, and we can't, Bryant and Anderson tell us that we can't, in hindsight, excuse the failure to conduct any investigation with the hypothetical strategic decision not to use its hypothetical results or whatever the language is. It can't be excused. We can't say it's trial strategy if we didn't do the investigation in the first place. And we can't hope that we vigorously can cross-examine someone to excuse an actual failure to investigate. Under the prevailing professional norms, which is the standard of Strickland, we have to look at what the reasonable prevailing professional norms are, and investigating a critical eyewitness is clearly something that should be done, and if you're to be.
Remind me, what did the lawyer say below in the proceedings? Didn't he testify?
He did, Your Honor.
So what did he say?
He said that about 7 days before trial, he was informed that Sandra Allen would testify differently and that he elected not to go interview her, and there was discussion because he didn't want to. He seemed to say that if he were to go and interview her, he would have to ask for another continuance, and they didn't want to ask for a continuance, so they were just going to try to cross-examine her. But had he gone to interview her, not only could he have learned the extent of what she was going to testify to at trial, but could have learned that she had a roommate who could corroborate that she didn't see the shooting, and maybe also would have learned that she gave an interview to the news.
The point is, this is not a happenstance that he failed to examine a whole chain of evidence that's out there, and when you have that, not just the single witness, that opened the door, and the competent counsel is going to go pursue that. You may decide ultimately what to do with whatever to do with it, but you don't. That's the difficulty. So in many ways, it's a failure to investigate characterization as much as anything else, and then going to the prejudice of it. That's a different question. You have it's a high bar.
It is.
It's a very high bar. It's in the last couple of years, it's gotten higher.
That is true, Your Honor. It is not insurmountable, though.
But the question is it just a high bar, or is there no case out there that's so bad and so egregious that federalism will not look away? Well, that's the state's decision. But that's our question.
Your Honor, until the Supreme Court tells us otherwise, that there is no more federal habeas corpus, I submit that this presents an ideal situation in which the state post-conviction case courts got it wrong, and the wisdom of this court, the wisdom of the Middle District, was necessary to rectify that wrong. Your Honor.
Remind me, just for, this is kind of off the larger point, but if I'm right about this, just remind me, the lawyer didn't try to contact the witness. I mean, there was no effort at all. In other words, he wasn't told, well, I'm not available till next week, or I'm not going to meet with you. There was nothing like that. He just didn't do anything.
He did not. He did not. He also, he did no investigation with regards to going to the scene and interviewing witnesses, which is inexcusable.
I suffer a disability looking at these things after 60 years in one courtroom or another. That somewhere along the line, I will say more, that it seems to me that we have to give a straightforward analysis when lawyers make mistakes, and sometimes they are devastating. And the system can handle that. There's a small fraction, very small fraction of the practice of criminal law in the state. 98, 99% of those go forward and smoothly, but they do it against a backdrop, and smoothly, that there are limits, and so that's the way that you would be thinking about the question of federalism. We defer mightily to the states in these things, and the Supreme Court decided that a long while ago that it would not review these cases on direct appeal from the state courts, but would route them through the lower system. And they went to only 98% of every cert petition filed in the United States Supreme Court was denied almost automatically, because they rerouted the cases back through the system itself. And through the rerouting, now they face this door. I'm not trying to hold forth on some abstract notion of the law. I'm just trying to frame the question that's before us. And the reality is that this is not some great intrusion into the state when 98% of the criminal practice goes on day in, day out. Most lawyers competently perform, actually. In my experience, the criminal offense bar are some of the best trial lawyers out there because they get to try cases, unlike the civil bar.
And it's easy for a post-conviction lawyer like myself to sit in the galley and pick at what counsel did not do. Yeah.
For whatever it's worth, I just wanted to
Well, I would concur. I mean, and I think that what Your Honor asked the question to an appellant earlier, what's your strongest case? I think that Anderson versus Johnson, a case that you guys, that this court decided.
Ever say you guys?
I'm so sorry. I didn't mean to say that. I apologize. Your Honor.
Trap door right down below. I have a button up here, and you will disappear into oblivion, never to be found.
I apologize, Your Honor. I didn't mean any disrespect. I did not. But I think that the Anderson versus, there are very rare exceptions. It's an extremely high standard. We don't dispute that, but it's in cases where there is not overwhelming evidence of guilt. Where
More to the prejudice. I mean, just elaborate a bit more on the prejudice aspect. I mean, the other hadn't gone away, but just articulate a bit more on the prejudice aspect of this.
As the district court found, had there been some, we have to show that there would be not conceivably a different result, but there would have been a different result had counsel performed this necessary investigation of Sandra Allen. Sandra Allen is the only disinterested witness who testified at trial that she saw a surrendering. George Hughes testified that there was a scuffle over the gun. This was corroborated by the pathologist who said that there was a contact wound. Had there been an adequate investigation of Sandra Allen, the result would have been different, either with a finding of justifiable homicide or with a finding of manslaughter. There's the only evidence of intent, and I think that my friend on the other side slightly downplays that Sandra Allen couldn't have added anything to this. Her testimony didn't really add anything to this trial. The only evidence of malicious intent, specific intent to kill, is Sandra Allen testifying that Drew Hawkins was surrendering at the time that George fired at him in cold blood. And so this was incredibly important testimony that bared, she was an incredibly crucial witness, and she should have been investigated. I hope I've answered your question, Judge Stewart.
Okay, you did.
Just
In a nutshell, I mean, in addition to Sandra Allen, just give me a check mark, 1, 2, 3, 4. What was the other evidence?
there was evidence that, I get confused with the post-conviction hearing and what was introduced at trial, but there was evidence,
Well,
there was an argument.
What other evidence was there that would have been
But Drew,
crux of the investigation? Had the investigation been whatever, I mean, what other evidence besides her, in addition to her, 1, 2, 3, 4, you know?
what evidence was?
She was a witness.
She was a witness,
So I guess
and-
we have forensic and that
Yeah,
kind of thing.
there-
I'm just trying to get in my head
Yes.
what the crucible of evidence was.
There was the testimony of Amy Hughes, which was inconsistent with her initial statement to the police that her back was turned, but she later testified at trial that she saw the shot and she saw Drew surrendering. There was the testimony of Sandra Allen. There was the testimony of George Hughes himself. There was the testimony of there was a fingerprint expert that testified there were 2 fingerprints on the barrel of the shotgun, or of the .22 caliber gun, that they weren't able to identify whose prints they were because they were insufficient for comparison. There was testimony, I believe, from the pathologist that this was a close contact wound, which would be consistent with a scuffle. And I'm out of time, but I would just...
In general, did the lawyer have sort of, we talked about Sandra, but the other evidence, did the lawyer have a grip on that evidence in terms of cross-examining, putting his witness on? I'm trying to get a flavor for...
Well, one of the claims in post-conviction, which is not before this court, was that trial counsel also failed to submit a justifiable homicide for a defense of others theory, that there was extensive testimony about the tumultuous relationship between his daughter Amy and her husband that could have been presented, that should have been presented, that wasn't, but that was not granted.
Well, I guess I was just trying, and this is just a takeaway, I was trying to get, I mean, we'll get it when we look at the record, I was trying to get this to whether, so the lawyer has a client, there's a date, says he doesn't want to file for another continuance, just grabs the file, you know, heads to the courthouse and, you know, sort of bootstraps it, so to speak. And that's what I was trying to get my head conceptually around without reading it all. Talked about Sandra Allen, but the rest of this is like, you know, whatever's in the file, you know, we sort of go with it kind of thing. So that when we're looking at quality of investigation in the wider context. I was just trying to get my sense of what that embraced.
And trial counsel testified that he consulted with a potential expert, that he didn't call it trial, that he kind of limited his review of, he reviewed the evidence, the police reports and things like that, but he didn't conduct any independent investigation, nor did anybody in his office.
Okay, all right, that's helpful.
Thank you. We would ask this court affirm the Middle District's ruling and to affirm the grant of habeas corpus. Thank you so much.
All right, thank you, Ms. Hogan. All right, we're back to you, Ms. Rutzen, for rebuttal.
Judge Higginbotham, to answer your question about, are there any limits on EDPA? There is one case that my colleague cites in her red brief. It's the Hinton case. Hinton. And it was a grant of habeas relief post-Richter due to finding that counsel's performance was unreasonable due to his ignorance of the law involving expert funding for indigent defense. I think it was a death penalty case, and his failure to research that point. So there are some exceptions. Our position is that this case does not present an exception. It's not in that 2%. And, the broader the Supreme Court principle, i.e. Strickland here, the more leeway the state court gets in reaching the outcome. EDPA tries to prevent a total failure of counsel. We're not even close to that. Whether you agreed or disagreed with what counsel did here, he took a lot of effort in defending Mr. Hughes at trial. One of the points he noticed and one of the pieces of evidence that he was really strong on was Mr. Hughes' testimony himself. He said Mr. Hughes had always insisted that the gun went off accidentally. He was going to maintain that defense from the time of his arrest up until trial, and that's exactly what he did. That it proved to be unsuccessful doesn't make him deficient. What matters here is if the Louisiana Supreme Court, or if the Louisiana court managed to blunder so badly that every fair-minded jurist would disagree with the result. And over the 11 years that this case has been pending on collateral review, we see some fair-minded disagreement. That is not enough under EDPA to grant relief. And my colleague, she might present a strong case for relief. But that does not equate to a finding of objective unreasonableness on the state court's decision. The Supreme Court meant what they said about double deference and about extreme malfunction. We see it in their per curiam reversals of circuit decisions in Mays and in Shin. Mere incorrectness or second guessing, which is so tempting, it is not enough to surpass EDPA's relitigation bar. And we ask this court to reverse the Middle District's grant of habeas and to reinstate the conviction. Thank you very much, Your Honors.
Thanks very much. Counsel on both sides, good briefing, good argument, and we appreciate the help. All right, the case will be submitted and we will get it decided. All right, we call up 20-20213, Hobbs, Lee, Arroyo.